Hello, and welcome to the arbitration conversation. So in this arbitration conversation, we are talking to a true expert and someone who is brilliant, Angie Raymond. Dr. and Professor Angie Raymond, she's the director of the program on data management and information governance at the Ostrom Workshop. This is at the University of Indiana. She's also an adjunct law professor there as well. She's worked extensively in the area of online dispute resolution and specifically with law and technology. In fact, she also has been a lead expert with respect to the APEC ODR program. And I've known her over the years in her area of understanding really beyond what I can understand. So I ask her for explanations as to AI and artificial intelligence or augmented intelligence. Angie, thank you so much for taking time for an arbitration conversation.
Thank you for having me, Amy. Nice to see you.
Well, there's been so much talk, right? We've had our own side conversations about this idea of, well, wait, could we have bot arbitration? And what about using AI for arbitration decisions? What would that look like in your view?
Well, I want to start with an explanation. I think there's two really important terms that you've used, and one is AI and one is arbitration. And I don't mean to be, completely, I don't want to go into the granularness of this full argument, but I was on a call last week talking to computer science informatics, and we're doing this plan. And I said, I'm curious what AI means to you. And everybody laughed because we realized that AI has become a phrase that actually has taken on a lot more meaning than what I think anyone really had intended. And in all fairness, when you're talking about technology in a justice environment, a lot of what we're talking about already exists and does exist and has existed for a while. And so most people, when they start talking about AI, are really talking about some of the fancy, snazzy stuff that they see. So that's my first, claim to fame, is that to be sure that I'm going to do my best to be very focused on what I mean by AI, but do understand one of the first things you have to really think about when you're reading someone who's using the term AI is, what do they mean by AI? And then the other thing I want to talk about is arbitration. And so this is a term that is so important for the lawyers out there to really become engaged in these tech-driven conversations. So the more we rely on tech, the more there are going to be questions about whether or not it meets the definition of arbitration. And this is not something that's new. So please understand the confines of the term arbitration have been, I suppose, under attack before. And we have excluded some things from the definition of arbitration previously. And I do think it's important to understand that one of the advantages of using arbitration as the mechanism of dispute resolution is that its outcomes are legally enforceable, but that demands that you comply with the basic notion of what arbitration is. And I suggest to you that no court process would allow arbitration to be used in a way that we otherwise got around rule of law, due process, and the idea of a justice environment. So when technology begins to push upon those aspects of arbitration, I fear we may start seeing awards not being enforced under the New York Convention, for example, or the model law, which is really the advantage of using arbitration. And so what you would end up with then is that the process of the outcome of this very tech-driven process would be nothing more than a contract, which means now you've got the same old problem we've always had. You've got to go into the court, you've got to interpret this contract, and you've got to make arguments about how we will interpret the contract after a breach. And that's not really the outcome we want. So the key to using AI, in my opinion, or using any tech in these environments, is to ensure that it's still compliant with what the idea of arbitration is, which is something that's part of a justice environment. And we're not going to allow due process and all of that to go away. Now, with that said,
arguably, maybe we should back up here a little bit, though, because just to push back on that to some extent, in the sense that, especially under the Federal Arbitration Act, it really all just depends on your arbitration agreement. So let's say that individuals start building into their arbitration agreement that they agree to a bot resolution.
That's true.
That could be enforceable.
Probably. So, it's interesting to understand that the reason that that clause is enforceable is because the courts have given over their authority and power So it's not that it's not enforceable as a contract clause. Most people really want the enforceability of that arbitration award because it really shortchanges the process of enforcement. So you can design a contract to use almost any system that you want, but it's an enforceable contract, which produces, when you renegotiate, basically in what you think is an arbitration, you produce a new contract that now has to be interpreted. So that's the push and pull of that clause. Yeah, probably can be enforceable. But there's questions if you want that sort of expedient, fast resolution after a process, after a hearing, you have to be compliant with the notions of rule of law. Well, and I'm not sure court would give that up.
Well,
necessarily.
And we might have a difference depending on if it's the Federal Arbitration Act or the New York Convention, because of recent Supreme Court jurisprudence.
Absolutely.
But the question I also wanted to get at is, at the beginning, you talked about, what you're thinking of as AI, which is such an astute thing that we have to talk about before we talk about anything else, because you're right. There's so many different ideas about, and a lot of times really all you mean are algorithms, right? Sometimes that's really what somebody means and not actual AI. So when you think about actual AI being used in arbitration, how would you define it?
Well, so I think AI long-term, I mean, if we're really talking about an environment that draws knowledge from people interacting with the environment, to me, that's what we're really talking about, is we develop an environment built on historic data, most likely, that then as the environment grows and more people interact with the environment, it creates a new data set that trains the environment to behave as the people in the environment are behaving. Very much machine learning driven by models. There are instances where that exists. So and I want to be really careful that I don't mention too many particular providers. I try to be agnostic in terms of the tech. With that said, there are some mediation negotiation platforms that clearly draw upon knowledge from the user's interaction with the environment and the way they behave. And I do think that is, at some point in time, we'll probably have to do a little bit of digging onto whether or not we're actually okay with that or not, because it would be deeply problematic if the technology is nudging you in a way that is not necessarily in a way that would benefit you. So if the technology is somehow not giving you full disclosure, or, my example in a couple of papers was, what happens if you're in an interaction with a particular technology and they know your push point is a $30 gift certificate because you've accepted it 4 other times? We probably would have a problem if the technology is nudging you that way against a right that you otherwise had. But if the technology is designed correctly and well, and with an idea toward, I suppose, fairness, which is another nebulous term, quite honestly, but at least a commitment to justice and ensuring rights. I think we're probably at the stage where those type of tech deployments are in fact being used, and are in fact being used in a pretty consistent way in various environments. And actually, without using any specific tech, there are court systems even that are using tech to assist in negotiating between, for example, divorcing parents, the visitation schedule. And what that technology does is encourages people not to use communication styles that are hostile, and keeps things simple and almost a text-based environment that nudges you in ways to not use some of the nastiness that can happen during a divorce. And that is all then can be stored, and you can submit it to the court. And so there are these technologies that are using natural language processing or other types of technology that are clearly learning in the platform itself, that are assisting people in accessing justice in different ways. I haven't heard that specifically used necessarily in arbitration, but that doesn't mean it couldn't. And it certainly would surprise me if eventually we don't see that more and more.
I love your point, though, that I think is really important. When you look at sort of the use of machine learning and the data set upon which it's based, I mean, we have to be careful. So we're not simply nudging replication of history, right? Because sometimes history might not be just. right? And
Yeah.
so that I think is a big issue for us to sort of grapple with.
Yeah, I'm incredibly concerned about how we train any machine learning in a justice environment, and I think it's important that everyone understands that the data sets that are originally used are historic, right? It's always backward looking to predict forward, and our justice environment in general has, I mean, you could sort of say systemic, and then almost add almost any word after it at various periods of time. And so whether or not you're talking about historic biases or historic racism, there are very significant periods of time in our justice environment, unfortunately, and that gets captured in the data. And, pretending that we can just take that out is a little oversimplistic. The technology, if it's truly learning, will just find a proxy for gender or race. And so, the tech is pretty good at drawing correlations and inferences. And so we have to be careful that we don't let that happen. The other thing I'll say is that I think the tech types would tell you that historic data is problematic also because that data that the court was generating 10 or 15 years ago was never designed to be used as a source of data in this type of environment. Courts saved that stuff so that 5 years from now, I can go back and find the court decision about my traffic ticket or whatever. So they weren't worried about creating data fields that allowed for us to do, real scientific research on it. So, now what's happening is, Georgetown, for example, I think is one of the institutions that's working really hard to try to go back through some of that historic data and sort of add some robustness to it. But that's a different conversation of what happens when we go back and make inferences and add robustness to create these data sets. I'm sure they're doing a good job on it, but it's a lot of legwork and hard work. And so I worry that we'll end up with sort of a more recent period of time where we look at historic data that's also going to be problematic in new ways, I fear.
Right. Oh, that's such an excellent point. I mean, my head is swimming. There's so many important, honestly, really important things to think about. And how do you sort of create that data set? And it's interesting too, because we know insurance industry is one industry, for example, where you could see building on prior cases, maybe with a car crash or whatever it may be. Right. Maybe there's a way because, actuaries have been hard at work in that space for a very long time. Do you think that might be an area that might be sort of more ripe for use of machine learning?
Yeah, I think it's probably true. So I think there are areas that naturally have always been maybe a little more commercial or value driven, mm-hmm. and have also been a little more attentive to capturing data in lots of data fields. And so, I do think that's true, that we have particular groups of individuals or industries, I guess, who have been much more data focused because there's value in data. It's just the courts have never, actually the courts and the government, quite honestly, have never really been good at understanding the value of data before it smacked them in the face. Mm-hmm. And now we all get it, but now we got to go back and try to recapture the data. Where the insurance industry, again, credit scores, all of those type of industries have always understood that key data points do have some value, and therefore they capture it, and they have created some standards as well for how you capture it. So there's a real big problem with the way we capture data in even something as simple as rounding, believe it or not. Mm-hmm. And somebody rounds and another person doesn't, and your data set doesn't always work well together. But, when you already have standards because you appreciate value and the need to share the data, then you have those standards that naturally will allow, one would hope, those data sets to be used in a justice environment much sooner than others.
Yeah. Yeah, I think though at the end of the day, we have to be really careful, as you note, and we've been talking about, in terms of this assumption, again, kind of the first statement that we talked about is this idea that, you're going to have bot arbitrators. I think you're absolutely right. That's just not going to happen. I mean, number one is you're right. We do have to preserve procedural justice and the legal environment. But also just the fact that, that data could be problematic in a lot of these cases. It may be more a matter of using data as you're seeing, as you mentioned with Georgetown. I know Stanford is also sort of looking to build kind of chatbots that can empower individuals with respect to their rights. Do you see promise in that sort of use of machine learning?
So the chatbots has produced an interesting conversation. So we are also in Indiana, the state of Indiana, working on guided interviews, which oftentimes is similar to what you're talking about, sort of helping people think about how to navigate the system, maybe fill in forms, answer basic questions. Where would I discover the information if I need to evict a tenant, or, those type of things. And we're being very careful about chatbots. I promise not to mention anyone, but this one's pretty well known. LegalZoom went through a real period of disruption that people were not happy that the tech types were helping people with even basic access to justice barriers, like what we're talking about. And there was massive pushback if they were practicing law without a license in various states. And so the chatbots, again, are going to have to walk this very interesting line. And when you talk to various states who are trying to deploy these chatbots, you'll find they have very comfortably put out chatbots in a lot of areas, but they're really hesitant in this area to jump on board too much because of the precedent set by these other disruptive technologies and where the line is for practicing law without a license. And right now, the law really assigns agency to the industry or the entity that's created the bot. And so with that in mind, it could really expose some people to some liability for practicing law without a license. I would hope, however, that we do, take a more robust approach eventually. I think there are so many people who really don't understand the simplest, basic legal questions that they have, that they would never use a lawyer. They don't really need a massive amount of help. They just need to know where the form is. And the form is actually pretty self-explanatory. And so something like a chatbot that could get you to the right place, that could explain your basic legal right, get you to the right form, and in a magic world, explain to you what some of the legalese on that form is, so that you can actually get some access to justice and maybe get a public defender or whatever it is. It really still bothers a lot of us, I think, that it's so difficult to just roll out things like that.
Yeah,
no, I need to make a change in that area very much.
Oh, 100%. We've got to be more innovative. And I love sort of the sandbox approach that Dino Jimenez has suggested and others. There's so much room to sort of expand access to justice.
Agreed.
Well, yeah, absolutely. Well, listen, let's definitely continue this conversation. We're probably going to need a part 2 as we watch how technology unfolds, because it's just been really great, really important points that you've raised. And I just really thank you for taking time.
Absolutely. Thank you for having me.